Woman has been arrested after a video pops up on social media showing her beating a 3-month-old puppy with a belt.
As KENS 5's Mike Jimenez explains, the video has upset thousands in the community who are now calling for justice.
Before you watch this case unfold, ask yourself one thing. What happens when social media outrage becomes a spark that launches a full-blown criminal investigation? Because today's story came straight from Facebook to a felony courtroom.
The video is heart-wrenching to watch, and we have to warn you, some viewers may find the video disturbing. The video is so horrifying to watch that we're only going to show it to you once. In a video posted to Facebook, Havana Miller is seen on...
This moment right here is where the entire legal conversation begins. Under Texas law, repeated strikes with an object can fall under torture if prosecutors can prove unjustifiable pain or suffering. And trust me, when a video goes viral, the pressure on authorities skyrockets. This isn't just public anger. It's a legal fuse being lit in real time.
On the balcony of an apartment complex in the 12,000 block of Culebra, holding a 3-month-old poodle while whipping the puppy with the belt 17 times. In the video, you can hear Miller yelling at the puppy while the puppy cries. The puppy eventually breaks away and runs into a corner. 2 more strikes follow. The video was sent to Sally Arnold, a member.
Imagine watching this video, feeling pure shock, and then driving straight to the suspect apartment. Would you confront someone face to face? This is where the story stops being just a viral clip and becomes a tug of war over a living creature, with money, threats, and police all closing in.
Of several dog groups on Facebook asking for help. Arnold posted it on Facebook Friday around noon. Arnold says when she saw the video, it broke her heart.
I just was bawling, and I don't understand how anybody could do that to a dog who can't defend itself.
Immediately, people saw the video and wanted to help. Renaya Rubio saw the video and went to Miller's apartment. She told Miller through her Ring doorbell camera that she witnessed her hitting the puppy and offered her $300 for the puppy, or she would call police and show them the video. Rubio says Miller agreed and said she did not want the police involved. Then Rubio says the price kept going up.
She's like, I got him for $1,000. Like, the least I can do is $750.
Rubio only had $500, so she began asking for donations. The video started going viral, and people were donating more money. But then Rubio says Miller now wanted $1,000.
We never got the puppy. Another source had called the cops and apparently had sent them the video. And so that's when the cops and ACS, I guess, got involved.
San Antonio Animal Care Services got a warrant and around 6 p.m. Friday picked up the puppy. ACS says Miller was arrested Saturday and is facing a charge of animal cruelty, torture.
And now the real battle begins. The courtroom. This is not sentencing, not a plea, not a trial. This is the pretrial motion stage. Specifically, a motion to quash the indictment, basically arguing that the charges themselves are flawed. If the defense wins here, the entire case collapses before it even starts.
A third-degree felony punishable between 2 to 10 years in prison. From what started as tears of sadness for Arnold turned into tears of joy after learning the puppy was now in the city's care.
I just want to make sure that she's not able to do this again.
A petition on change.org was started demanding the maximum sentence for Miller. At last check, more than 8,000 people had signed the petition. We did reach out to Miller, but have not heard back. Mike Jimenez, KENS 5.
All right, we are going to go on the record. The court is calling 2025 CR 001454, State versus Havana Dejanay Miller. Could I have parties announced?
Lauren Espinoza and Jason Garrihan for the state.
Jody Sawyers and Jared Hall as attorneys for the defendant, Havana Dejanay Miller.
All right. And are you Miss Miller? All right. So we're here today to hear pretrial motions. I think it is best to start with the motion to quash, because if that were to be granted, then the other motions will not need to be heard. So the court is in receipt of the true bill of indictment, and the court is in receipt of the motion to quash the indictment and a memorandum in support of the defendant's motion to quash the indictment. State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, you may proceed.
Yes, thank you, Your Honor.
Oh, you can remain seated and if you'll speak into the microphone, that way I can hear and the court reporter can hear.
Thank you. All right. So, the issue with this statute is very specifically in regards to it's the torture provisions of 42.092. And what I mean by the torture provisions is in 42.092 B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. The definition of torture is an unjustifiable, an act that causes unjustifiable pain and suffering. And while that might sound, sufficient, it's super, super vague. And it becomes even more vague when you look at the rest of the statute and how in the allowable conduct that it permits under the statute. So I do have a copy of the statute. It's actually for the court. It's actually chapter 42, most of it. It's gonna include section 4209, cruelty to livestock, and then right behind that, it's gonna include
I'm sorry, you gave me 2 copies.
Okay.
I don't know, the state may need an extra one. Thank you.
Do y'all need an extra one? Okay. And then right behind that, you'll find the cruelty to non-livestock at 42.092. When you look at these statutes between livestock and non-livestock, they are identical in regards to the torture provisions. The only difference is that livestock is limited to intentionally and knowingly, whereas you have the mens rea, and then non-livestock allows you to go to recklessly. So that's the only difference is the mens rea. The definition of torture under livestock, cruelty to livestock and cruelty to non-livestock is the exact same. That's important because when we look at what our society has determined is acceptable or justifiable pain and suffering, we have to understand that the context is the same regardless of whether the animal is non-livestock or livestock, even though this is pled under the non-livestock provision. Okay, then turning your attention to the actual statute of 42.
And now the real battle begins. The courtroom. This is not sentencing, not a plea, not a trial. This is the pretrial motion stage. Specifically, a motion to quash the indictment, basically arguing that the charges themselves are flawed. If the defense wins here, the entire case collapses before it even starts.
0.092, I want to bring your attention to section B and B2. And it says a person commits an offense if the person intentionally, knowingly, or recklessly, without the owner's effective consent, kills, administers poison to, or causes serious bodily injury to an animal. So by implication, if you have the owner's effective consent, it is not illegal to kill, poison, or cause serious bodily injury to an animal. Then, if you proceed downwards, it allows under B6, it allows that someone, if they have the effective owner's consent, to cause an animal bodily injury.
So are you saying that according to this part of the statute, if you are a pet owner, then you can poison your pet, you can beat your pet, and that's not a crime?
And that's what is concerning about the absurdity of this statute, but that is the statute. Basically, what it's saying is if somebody else does it to your animal and you give them consent, it's okay. But read it, and that's what I'm saying. It says under B, a person commits an offense if the person intentionally, knowingly, or recklessly, without the effective consent of the owner, kills, administers poison, or causes serious bodily injury. So they can do it. It's not as long as they have the effective consent of the owner. So
isn't that related to if you take your doctor in for veterinary care?
Well, you
have the animal euthanized, that you're killing the animal and the owner has given consent?
And that's a great question. But if you look further, it actually has a provision that deals with the like a veterinarian services. And let me see, it is a defense on D.
Mm-hmm.
It is a defense under that if the actor had a reasonable fear of bodily injury, if the actor was engaged in a bona fide experimentation of scientific research, or under E, if it was discovered on the person's property, or 2, the person killed, injured the animal within the scope of the person's employment as a public servant. And then it goes on. So I don't think that well, I think that's a great question. I don't see the actual, well, but it's a public servant. So, I mean, I don't see where it says actually a doctor, but you see what the problem there is that by saying, oh, that's just to allow a doctor, it is not limited under the statute for that purpose. It's saying anybody. And when you look at animals are considered under our statute or under our laws as chattel, as property, which is just the way our society has defined them. Whether I agree with it or I don't agree with it, the civil courts will not allow you to collect money, civil damages, for the loss of your emotional attachment to a dog. And there's a case that we have on that. It's cited in the paper. We can provide that to you. So what they do a great job of.
Well, that's civil.
We're
just here under the penal code.
Yes, Your Honor. And so, but the point is that the status as property is what is triggering the owner's, why you have to have the owner's effective consent, because our laws, whether they are civil or criminal, still see animals as property. They don't see them as having the same rights as a human.
But are you, even with regards to this section that says without the owner's effective consent, are you arguing that you can still kill an animal in a cruel manner?
I'm not arguing that. I'm saying yes.
Or cause unjustifiable pain?
So that part I am arguing with, because that is so broad as to undo all the other rights that you would have. Because when you say unjustifiable pain, does that go to emotional pain? It's not limited. It doesn't even and that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just calls a dog unjustifiable pain and suffering without requiring any proof of bodily injury. Humans don't even get that level of protection. Humans, you can't be charged for having caused someone emotional, like with a crime, for having caused them emotional injury.
Is the indictment, are you all charging this indictment as causing emotional pain to the animal?
No, Your Honor, the indictment's charging under the first section, under D1, that says torture.
All right. So they're not, my understanding, and if I'm wrong, please.
This is where things get legally messy. The defense is essentially arguing, if an animal is considered property and the owner gives consent, can the law still call it cruelty? It's a bold strategy, one that relies on statutory ambiguity, not on denying what happened in the video. This is a classic courtroom move. When the facts look bad, attack the wording.
Correct me. My understanding is nobody is charging her with causing emotional pain, allegedly causing emotional pain to an animal.
So if you have no bodily injury to an animal, then what's left?
Isn't that a fact issue for the jury?
No, I don't believe so. I believe that our law will not allow, like, written as broadly as it is in conflict with every other provision that we have in our codes. Because if you look at the bodily injury, like for instance, a human assaulting another human, we specifically state in our definition of bodily injury that it is the
Causing pain?
Yeah.
Is one of them.
well, it's causing pain, but the thing is that it also it will not allow for someone to be criminally prosecuted for emotional harm or pain, and we distinguish that by saying that it has to cause bodily injury. Here, the problem with this statute is that torture provision does not require bodily pain. If anyone shows that there was no bodily injury, whether and it's a different topic whether you could include pain or it would require physical bodily some type of visible injury, that's a completely different issue. But just assuming for the sake of argument that if we are going to require and limit assault to bodily injury on a human, we definitely can't not require it for an animal who, under our laws, has historically and still today gets less protection. I mean, a prime example is our horse racing. We have animals that are routinely raced and beat with crops. And the reason I bring that up is because this one specifically names repeatedly striking a dog. That's the manner in which they claim. So the point is that our society has said it's justifiable to beat a horse with a hard crop for horse racing and making money, and that's justifiable.
Well, that's something that needs to be taken up with the legislature on the fact that maybe people don't want horses being beaten. I know some people complain about maybe in other countries dogs are eaten for food, but then people have a different idea of how dogs should be treated as opposed to livestock, as opposed to horses, as opposed to chickens. But that's something for the legislature to change how different animals are treated and how they're treated in sports. So my understanding, and again, if I'm wrong, correct me if I'm wrong, the state is not charging